Well, good afternoon, everybody. It's noon, and it's great to see you all. And thank you very much for joining us on this next edition of CondoWise Learning. We're happy to have you with us, and we just ask that you keep your microphone muted and turn off your video. And if you'd like to ask questions, we'll take them in the body of our presentation, but you can use the chat function. Now that we're all becoming technically savvy, these things all mean something to us now. I never knew what a chat function was until this pandemic. So to start us off today, and if we could advance the slide, please. We have Victor, myself, and Julia to talk about what's happening with the Condominium Authority Tribunal. It's a very exciting day because things are changing as we speak. So Julia is going to start us off with our presentation. Next slide, please.
Okay, so first we're going to do a quick pandemic update as we do at the beginning of each of our CondoWise sessions. So I think there are some really big questions right now with respect to COVID-19, namely, why the numbers are increasing again, why they're increasing so quickly, whether we're officially in a second wave, and what the future holds. I know the Ontario government is looking for some creative and more targeted ways to control the spread without having to shut down the economy again. But again, we don't know what the future holds. But we do know that we need to take a look at where condominiums may have relaxed their standards regarding COVID-19 and the preventative measures that were put in place recently and that continue to be put in place, and where they need to up their game again. So with respect to guests and visitors to the corporation, condominiums need to make sure that they're taking all necessary and reasonable precautions to ensure that anyone that's entering on the premises doesn't present a danger to the community. It's not enough to just take an individual's temperature and let them, come on the property and do what they're there to do. In addition to temperature taking, they should also be required to fill out a COVID-19 questionnaire, which is something that we've discussed on our first CondoWise session, when they sign into the building and each day that they attend, confirming that they're not experiencing any symptoms of COVID-19, that they haven't experienced symptoms recently, and that they haven't been exposed to anyone who's tested positive for COVID-19. So as per public health guidelines, everyone should continue to do the following, and condominiums should continue to enforce the following. That is maintaining the 2 meters of physical distancing between individuals, washing hands frequently, wearing a non-medical mask in closed spaces or where physical distancing isn't possible. This is especially important in elevators and hallways and other amenity areas. And then advising individuals, including employees of the corporation, to stay home and isolate if they think they're experiencing symptoms of COVID-19, and also to encourage people to go get tested. With respect to gathering sizes, some things have changed recently. The maximum number of people permitted to attend informal and unsupervised gatherings, such as parties and dinners, is now 10 people indoors and 25 people outdoors. So this relates to any place other than a business or organization that's operating in accordance with Ontario Regulation 364/20. So for example, bars, restaurants, and gyms. There are also new requirements in place for bars and restaurants in Toronto. One of the most interesting being that contact information taken from those visiting the restaurant or bar must be taken from all individuals who attend and not just one on behalf of the whole group. So these new gathering limits will affect some of the condominium's common elements, which have already been opened or that the condo is planning on opening. So for example, if the condo has a party room or a rooftop, and anywhere that allows events or gatherings. The rules and protocols pertaining to these amenities will need to be modified to ensure compliance with the new guidelines. The board will also need to reflect on whether these new changes apply to other amenity areas, such as gyms and libraries. So under the Ontario regulation, commercial gyms are still permitted to operate under the 50-person limit, but there is a question for condominiums now as to whether the gyms and other amenity areas fall under the commercial category. So boards will need to carefully reflect on these constantly changing parameters of the pandemic and ensure that their board minutes show that they've considered all the issues and risks and that their decisions are based on reasoning. So the gathering limits will also need to be considered with respect to owners' meetings, especially AGMs, for which the deadlines are fast approaching.
Next slide, please.
Okay, so next we just want to provide a quick update regarding AGM deadlines and the need for electronic meeting and voting bylaws, which we discussed during our previous CondoWise session last month. So the deadlines are here up on the PowerPoint for your review. At this time, we're not really sure if any of these deadlines are going to be extended by the government, but condominiums should plan and operate as per the current amended deadlines. So what happens if the board spends money preparing for an electronic meeting and then the gathering sizes increase again? I mean, this may seem unfair, but the board just has to prepare for the current political and legal climate, and you have to do what's possible and plausible right now. So it's also important to mention that these deadlines are not to get the actual bylaw passed, they're to hold the AGM. So with gathering sizes now decreased to 10 and the future uncertain, condominiums need to make it a priority to get those voting bylaws in place and to come up with a plan to hold their AGM. And these bylaws must be passed in a meeting of the owners and therefore must be passed before November 21st. So Patricia, do you want to provide just some insight as to how this process will work?
Sure. Thanks, Julia. I think, it's about becoming practical on how we can execute. We know that one of the things that is a challenge is that there are perhaps not enough service providers available to host every single meeting that we need to hold within this time frame. But right now, let's just focus just for a second on that meeting, specifically to pass that electronic voting and meeting bylaw. Now is the time to get it done before the November 21st deadline. And what you can do is you can actually set up the meeting, send out the notices, and host your own meeting. I know that seems scary, but using a Zoom platform, cooperating and working with management to collect proxies, and then holding a meeting just for the sole purposes of managing that issue, that is the bylaw for the meeting and voting purposes, will go a long way in getting you to getting those AGMs set up. For example, at Aaliyah Associates, we've drafted a bylaw that allows for electronic and in-person meetings and hybrid meetings. So it contemplates the use of technology in the context of a multitude of different types of meeting combinations. And I think that's important. Think about flexibility in your bylaw, because you want to address the concern and fear perhaps in the community that all meetings will be electronic. No, that's not necessarily a requirement, but we do see, as we learn about the pandemic, as we reflect on the impact of human interaction, that meetings will evolve. They will evolve with the integration of technology even into the live meeting. So that's what we should be planning for. In our last CondoWise session, we talked about hybrid meetings, and we talked about the platforms and the considerations from a technological perspective. So you should check that out. But, I think you really do have to get on the path of helping your boards ensure that they have that bylaw in place. So, Julia, why don't we go to the next slide and you can talk a little bit about the CAT.
So our big topic for today is the Condominium Authority Tribunal, also known as the CAT. The CAT is an online administrative tribunal that uses online dispute resolution to help people resolve certain types of condominium-related disputes more conveniently, quickly, and affordably than the courts. It was created in 2017 when the Condo Act was amended. So a tribunal is set up by government legislation to make decisions on behalf of the government when it is impractical or inappropriate for the government to do so itself. Tribunals make decisions about a wide variety of issues, and their decisions may be reviewed by the courts thereafter. They're often seen as being quasi-judicial because they engage in fact-finding and then have the power to impact people's personal rights. They're also meant to fill the gap where access to justice is increasingly lacking. So the CAT uses a three-stage process. Stage one is negotiation, where users work together to resolve their dispute. Stage two is mediation. If users can't resolve the dispute in stage one, they work with a CAT mediator who will assist them in coming to a resolution. And then stage three, tribunal decision. If the users can't resolve the dispute in stage two, the CAT will hold an online hearing and then will make a determination. All stages of the CAT will take place online, so the tribunal is very pandemic friendly. After stage 3, if necessary, there is the ability to appeal the decision if you think there's been an error with respect to a question of law. So there's 2 options. You can file an appeal with the divisional court, or you can file an application for a judicial review. Both of these options are complicated and time-consuming and sometimes costly, so it's advised that you seek help from your legal counsel before proceeding. And the appeal must be filed within 30 days of the date of the order or decision. Next slide, please, Zainab. Okay, so under section 1.36 of the Condo Act, a corporation or an owner or mortgagee of a unit can apply to the tribunal for resolution of a prescribed dispute with one or more owners, occupiers, mortgagees of a unit or the corporation itself. So the kinds of prescribed disputes that the CAT heard as of yesterday were with respect to disagreements about the right to access records and the quality of the records being kept by the corporation. Effective today, things are changing at the CAT. Victor, can you please tell us what's changing as of today?
Sure, thanks, Julia. So essentially what's changing October 1st today is that the CAT is expanding its jurisdiction to include what I'm going to call PVPS issues. So pets, vehicles, parking, and storage. And anything to do with those 4 issues, it also is going to include what we call chargebacks regarding those 4 issues. So if, for example, you have a pet that's pooped on the common elements, you've cleaned it up, and you want to charge back that cleanup fee, that will actually be part of the CAT's jurisdiction to decide. So we're going to talk about it in more detail today, but I do want to make everybody aware that this is now the regime we're living in, and that condos should therefore be more cautious about charging back these kinds of issues. We're going to get into very much a lot more detail about how the condo can deal with this regime going forward. But for now, I do want to make everybody aware again, that's pets, vehicles, parking, and storage, and chargebacks related to those 4 topics. That is now within the CAT's jurisdiction to decide, even though before it was just records. Now it is these more 4 contentious issues. These are more what we call heated and evidentiary issues, because usually in a records request, you just need to look at the documents. Were they disclosed? Yes or no. Now we're going to get photos of puppies. We're going to get photos of cars in garages. We're going to get photos of old cars in parking units. We're going to get a lot more evidence and a lot more heated debate about what constitutes a pet's, nuisance, danger, what constitutes a leaking vehicle in the parking garage, and all that stuff. So it's going to get a lot more contentious at the CAT. Next slide, please, Zainab. Julia, did you want to talk about this expansion?
Yeah, so the next question regarding the CAT is whether or not it will have exclusive jurisdiction over these prescribed disputes. So under section 1.42 of the Condo Act, which is up here on the PowerPoint, the CAT does have exclusive jurisdiction over the prescribed disputes that are set out under Ontario Regulation 179.17, which Victor just talked to us about. So this means parties can no longer bring such a dispute before the court or through mediation and arbitration. Instead, these disputes must come directly to the CAT. Proceedings that are brought in an improper venue are at risk of being dismissed for lack of jurisdiction. So as set out under Ontario Regulation 179.17, the new expanded jurisdiction of the CAT has 3 exclusions. So jurisdiction does not include a dispute that is also with respect to Section 98 agreements. Such a dispute will still go to mediation arbitration under Section 132 of the Act. It does not include disputes involving an electronic vehicle charging system agreement under Section 24.6 of the General Regulation to the Act, and Section 117 of the Act, which prohibits activities likely to damage property or cause injury. So any dispute under Section 117 will go to the Ontario Superior Court. Relief for oppression under Section 135 of the Act will also still remain under exclusive jurisdiction of the courts. So now I'm going to turn it over to Patricia to give us some more insight on what these changes really mean for unit owners and condominiums.
Okay, well, thanks, Zainab. I'm looking at it for points of reflection for the future as we move and transition into this, but I think what we need to think about is the evolution of a DSA making an abundance of sense. Condos are non-for-profit, they're the largest investment for many owners, and they are someone's home. Cost-effective and timely resolution by a specialized body as opposed to the courts is a good idea because the courts are stretched and not always do they have the specialized knowledge. We've seen that in a variety of decisions at times. So where does the balance lie? What is the value of the courts? I think the courts bring oversight to ensure that the tribunal operates within the principles that are defined as the rule of law and under the Condominium Act. Thus, an administrative tribunal or a DSA cannot rewrite the law. They are bound by it. There can be no arbitrary, capricious, or unreasonable decisions, as has been reiterated by the Supreme Court of Canada in many of its rulings. Ensuring reasonableness, this is now the standard, as the standard balancing against specialized expertise, something that judges do not always have in the condominium domain. What does that mean? It means that we're going to look at reasonableness in the context of what the statute requires, and as well, what does that mean given that condominiums are specialty? They require special layered knowledge. And the courts provide a source of appeal. They provide a source of appeal where the administrative tribunal has stepped outside the bounds or is seen to or perceived to have stepped outside its bounds. So there is always going to be this oversight. Condos are really perfect for the administrative law forum. But there are other issues as well that are perhaps not ideal, such as oppression. Why is that? Because oppression is an equitable remedy, another part of law that requires perhaps more flexibility and knowledge and the powers of a court. Next slide, please. So further points of reflection, the evil board versus the innocent unit owner, repeat offenders, to enforce or not to enforce economic impacts, and how the changes protect consumers, and a little bit about oppression are all relevant. Next slide, please. So the evil board, let's define evil. Compliance is a statutory obligation. So what about the board that takes it too far? There is a reputational cost. There is also a resource cost, but to whom? The innocent owner. Let's define innocent. Who is innocent? Condominiums and unit owners are both parties under Section 119, that are obliged to comply with the Act. So it doesn't mean that only the corporation can expect compliance. Owners can also expect compliance. But what if the innocent owner is not so innocent? What if the innocent owner starts a false or improper claim? Then takes it too far? What are the parameters around this? There is, again, a resource cost that we need to reflect on. Next slide, please. So when people break the rules over and over again, what will happen? Will repeat offenders have a record? Will they know? Who should keep that record, the condo or the administrative tribunal? Will it impact repetitive appearances at the CAT, and how should it? So when people ask for a record for the last 12 years, every single month, how will this be dealt with? We know that these are practical things that happen at the corporation level. There is a right to records, but who decides what is reasonable and on what basis? And then, the interesting thing is in the changes in the Act, there is no requirement to prove the merit of the request. So what if somebody is actually thwarting the operational function of a condominium corporation? And that's why I brought up the fact that we as condos are non-for-profit. So it's going to be interesting to see how this is addressed. Next slide, please. With respect to enforcement, there are real pros. Compliance with the Act, declaration, Act, declaration, bylaws, and rules in accordance with the Act, fulfilling the unit owner's expectations. Everybody bought into the Constitution. That's the declaration and the Act. So there is also an obligation. There's also the enforcement of the rule of law and a legal framework. And it's also, when it's done properly, there's a pro around marketability. If you have a well-run condo, the market is becoming so sophisticated that consumers know, purchasers know. But enforcement also has its cons. a resource drain, harassment of staff, for example. Who has the skill to decide this? We would look to the OHSA for the standard because a condominium is a workplace. So we also need to ensure that there is also the expertise to provide governance on that decision. What about abuse in the workplace? Again, who has the skill to decide this? And what is the deterrent to bad behavior? Are there going to be enough incentives to commit to enforcement? Next slide, please. So how the CAO and CAT must deliver consumer protection. There are many aspects to be protected, but the two key ones are legal expectations, i.e. rights, and financial interests. So how do you get this done? Specialized knowledge we've talked about. I think the next one is very important. Front-end methods of resolving disputes early. This is critical. Faster resolution is also promised at the CAT level. And this will come if the early dispute resolution pieces work. In British Columbia, when I look at the statistics, it seems like that people start in the system, they resolve their disputes early, and that lessens the amount of dispute that actually end up having to be heard. Mediation also forms an option within the system, and there are lower costs to entry, which is helpful. Cost-effective operations are paid for by users via fees paid by condominiums. So I'm a little on the fence here if it is as cost-effective, and I'll explain why as we go a little bit further down this path. Next slide, please. So cost of operation. Who bears the cost of operating the CAO? Condominiums, right? Because we're paying the fee. Who bears the cost of compliance? The parties? We'll have to see how that plays out. Like I said, there are low entry costs, but should the costs be so low? Are they real? Are the costs going to the CAT for all parties? So are there costs for all parties going to the CAT? Yes, there are. There are real costs. There are property management costs. There are legal costs. There are legal costs on both sides, unit owner, as well as the condominium corporation. So my question is, reflecting forward, should the cost be borne by the parties? The innocent owner or the innocent condominium? That's not the way the courts work. And that's not the way the Act was legislatively formulated as far as I see it. Section 134 basically allows for the granting of an order to allow costs to be allocated back to the party if they were actually not compliant. So it'll be interesting to see how that is effective. Now, under this model, depending on how the rules are interpreted, costs of the dispute will be shared by every member of the community. This has an economic impact. Price per square foot will change because budgets will have to change to include legal fees. Accountability. Are we potentially getting rid of real accountability because there are deterrents embedded in the system? So what are the costs? The cost to operate the CAT, which is not the same as for other tribunals. Here, the CAT and its budget is contributed to directly by condominiums. The Human Rights Tribunal, that is not the case. That is paid for through the tax base. So what is the defining line of contribution there? There are also perhaps no costs awarded, and that could be a removal of a deterrent. The courts have recognized that the cost of a chargeback and the cost of the award can be a deterrent of bad behavior. Then it's also potentially deterring advocacy. And Victor is going to speak a little bit about this after me and what that means. And then it could also be inviting director negligence and director liability. And Victor can expand a little bit upon this about the desire to comply or enforce compliance or not. You know, what I would want to not see, and I'm just giving my opinion here, is that I would not want to see boards stop enforcing. I would not want them to be nervous about the cost. I would want them to be thoughtful. Yes, look at the indemnification provisions, and Victor can speak a little bit to the impact of MLANI, but at the same time, I do think we need to think about this. If we put our directors in a position where they don't enforce, will they be negligent? Will there be increased D&O claims? Does that result in higher insurance costs? And where will we find volunteers? I think it's very interesting, and I speak as a condo director, and Victor, who's speaking after me on this, can also speak to what it's like to be a condo director. You know, we at Aaliyah Associates have taken on that role so we become better familiar with being a director. And my question is, will I want to sit on a board where there is no enforcement? There is then a breach of the act. That would concern me. I might be in the minority and I'll always voice my minority opinion, but I don't want it to be driven by financial considerations. There's something more important and at play here. As the fourth level of government, compliance is valuable. So I'm going to pass it now to Victor, who's been taking notes and quietly sitting there because he's got a lot to say on this. And Victor, can you give us some more insight, please, into this?
Sure. Thanks, Patricia. So essentially what I think is our main concern here at Aaliyah Associates is that there's a huge issue of chargebacks and legal costs are no longer going to be very straightforwardly recoverable from unit owners. So let's go back to the example of a pet owner who lets his dog defecate all over the hallway. Now, you find out that this pet owner is on surveillance camera footage. You have, let's just say, even a DNA evidence provider that has sampled that dog poop and has said, yes, it is that dog in unit 101. Let's say you have all that evidence and you are within your rights to charge him back for the cleanup costs, the DNA service provider costs, and even the cost of the legal enforcement letter that your lawyer sends to this owner. Now, when this owner gets that chargeback letter and sees that he's being charged back, let's just say even $40 for the cleanup costs, he actually can take the condo now to the CAT. So as of October 1st, 2020, today, he can actually file an online application, pay the, I think it's $125 or something like that, fairly low amount of fee to basically take it all the way through stage 1 negotiation, stage 2 mediation, and stage 3 adjudication, all the way to basically what we call an online hearing, costing the condo thousands of dollars in legal costs and costing the condo's manager, lawyer, board members, this whole headache of having to go through that whole 3-stage process. At the end of the day, let's say the CAT says, condo, you were completely correct to charge him back. You have the DNA evidence, you have him on surveillance footage, you have every right to do so. The problem now is, will the CAT award the condo with their legal costs? So far, based on the case law from the CAT so far, and based on the CAT's own rules of practice, that's not likely. The CAT has said time and time again in the past 2 years that it's been in operations, the CAT will not award legal costs even if the party is correct. So even if the condo is entirely correct in basically charging back this guy for his dog poop, it doesn't matter, the CAT does not award legal costs. This is the same sort of regime and rule as in the Human Rights Tribunal. The Human Rights Tribunal of Ontario does not award legal costs either, and that's why a lot of condos these days have human rights defense insurance, because we all recognize that the HRTO does not award legal costs. There is no, as far as I know, insurance that will cover the CAT file right now for condominiums. However, I'm sure the insurance industry can respond in due time. Right now, in the immediate future, from now until, let's just say, next year, our main concern is that will condos be scared to charge back a pet owner, for example, for their dog poop? It might be the case that condos will now take a hard look at it and go, well, we don't really want to risk having him take us to the CAT and spend all this money and all this time and effort for a $40 chargeback. That's our concern, and that's what we're trying to tell the CAT and the CAO. Look, there is now a real problem now, as of October 1st, of condos no longer being willing to charge back and enforce the rules of the condominium, even though, as Patricia mentioned, there is a legal duty under Section 17 sub 3 of the Condo Act for a condo to take all reasonable steps to enforce their rules. So now the condos are stuck between a rock and a hard place. Do we charge back? Do we take the risk on of going to the CAT? And then at the same time, if we don't charge back, and let's just say their neighbor who has to, walk past that dog poop every day says, condo, you are no longer enforcing the rules around dog poop. I'm going to take you to court now because you are no longer taking all reasonable steps to enforce the rules of this condominium. And I don't like dog poop. I don't want to step in dog poop in my hallway. So yes.
So Victor, I just wanted to ask you about, then what, would that be recourse under oppression, like under section 135?
Right, so a condominium unit owner, let's just say the neighbor of unit 101 sees a dog poop in the hallway and knows that the condo is no longer enforcing because they're scared of costs. That neighbor could take the condo to court under section 134, so that's compliance with the act, basically saying that the condo is no longer complying with its own legal duties under the act to try and enforce the condo's rules, or actually it could do both. The unit owner could bring an application to Superior Court and under 135 of the act, which is the oppression remedy, saying that the condo's failure to enforce is oppressing his interests as the neighbor of the pooping dog owner to not be subjected to the health hazards and nuisance, whatever, of dog poop in their hallways every day. So we're trying to tell the CAT and the CAO that governs the CAT, you've got to take a look at your rules. You got to take a look at the cost rewards that adjudicators are going to be allowed to basically award a condo, and basically, hopefully, send a message out to everybody, all the condos out there in Ontario, saying you can still enforce. We will still award you legal costs if you do have a good case of enforcement. So don't be scared to enforce. That's our concern. And so the main concern we have going forward now is chargebacks for these, again, these 4 issues: PVPS, parking, vehicles, pets, and storage. So from now on, as a manager or as a board member, you have to look at, does this issue fall within those 4 categories? If so, you should either talk to your managers, talk to your legal counsel, figure out what's the most cost-effective way and the easiest way to go about this. One thing that Julia did mention is that there is still what we call an escape hatch. An escape hatch under the the Condominium Act is 117 of the Act. So section 117 of the Act says that if it's a dangerous condition, if it's likely to cause personal injury or property damage, then that can still go to Superior Court. So you are no longer stuck in the CAT. If, for example, let's just make a better example, the dog owner, the pooping dog owner, his dog is not only pooping in the hallways, but also biting people, jumping on people, causing personal injury, or being likely to cause personal injury. That's a section 117 violation. That's a dangerous condition on site. You can still go to Superior Court, and the Superior Court can still award 100% of your legal costs. Now, obviously, that doesn't happen every time. The judge of the Superior Court still has discretion, but at least under 134 of the Condo Act, the condo is entitled to seek all of its legal costs back, instead of in the CAT, where again, the CAT does not award legal costs. So what'll be interesting is that the CAT will have to decide the indemnity clauses in a condo's declaration. So as I'm sure most of you know, in order to charge back somebody onto their unit's common expense ledger, the condo has to have that authority in the declaration of the condo. And so every declaration in every condo is different, and different condos have different types of indemnity clauses and different wording in their indemnity clauses. So if it is a narrowly drafted indemnity clause, for example, the indemnity clause that was at issue in Mlani that Patricia kind of referenced. In Mlani, the smoking unit owner basically said, look, the indemnity clause does not apply to this smoking violation. It was only meant to capture things to do with, common elements or other units. For example, me damaging other units or damaging the common elements. It does not encompass my smoking. So the Superior Court actually agreed and said, that's true, that indemnity clause is too narrowly drafted, that does not apply here, condos should not have charged back. So going forward, the CAT will have to look at these indemnity clauses in every condo and say, does this apply? And if it does apply, then the CAT might say, look, the chargeback for the cleanup cost, the $40, that is chargebackable, that's fine. What we don't know is whether the CAT will also say the legal cost of enforcing that is also chargebackable because it falls under that indemnity clause. So we don't know what the CAT will rule. The CAT's rules of practice are not in favor of condos right now, and the CAT's own case law is not in favor of awarding legal costs to condos now either. So that's our concern. Finally, Patricia mentioned, as a condo director, or at least a former director of my old condo and a condo resident and owner now, I will definitely be looking at every single issue that comes across. Like, for example, when I see dog poop on the common elements, reporting it to management, but at the same time wondering, is it worth it? And that's my concern as a unit owner. Is it going to have a chilling effect on not only managers and condo boards enforcing dog rules and dog or dog nuisances? It's also going to have a chilling effect on unit owners reporting it to their managers as well. So for example, if I lived in a tiny, let's say 10-unit condo, I pay 1/10 of those legal fees anyway. Do I want to report this dog poop to my manager and have them go to the CAT and spend $10,000 on the CAT fight? Maybe not. So that's my concern going forward. And maybe one last point before I leave you back with Patricia is essentially the role of advocacy. So I'm not sure if everybody's followed all the 4 articles I've now written on this issue, but the CAT, because it does not award legal costs, is now forcing basically managers and or board members to represent the condo at the CAT, because that's more effective than having more cost effective, than having a lawyer do it. It's not more effective. I've written articles on our website, you can check them out, saying why and raising examples of how it's not being as effective as a lawyer could have been, and has actually exposed condos to more risk because managers aren't insured for it generally. The directors and officers are not always insured for basically what we call legal advocacy. And so what ends up happening is that the CAT is now forcing everyone to do it themselves, when really, especially now with this expansion of jurisdiction, it's going to be a harder fight, a more contentious fight, more evidentiary fight that really should involve at least a paralegal or a lawyer to help prosecute it on behalf of the condominium corporation. So with that, I'm gonna take it back to Patricia, and then we'll talk about the questions that have come up in the Q&A chat here.
Okay, thanks, Victor. And you know, I think it's also important to look at the merits of advocacy by people who are skilled in the area of presenting the legal positions of a party. I think there is merit, because here's the thing: I don't manage a condominium corporation at the standard of a licensed professional property manager. I don't have my dentist do my property management. I have my dentist do the work on my teeth because they're trained. What I've learned is that condo lawyers actually are well versed and are knowledgeable and are actually the creators of a lot of the case law that helps provide structure to this act. The act, when I first saw it, was a very thin little document and booklet, and it keeps expanding, and I think that's good. Because, you know, where I came from prior to practicing condominium law, I worked in the banking field, and the Bank Act is, first of all, it's about 6 inches deep, and then there are about 50 or 70 regulations that go with it. Condominiums are complex. I think having knowledgeable advocates is a good way to actually efficiently manage the dispute so that we don't become tangential. I think it's unfair to put people in positions that they're not really prepped to argue. And, you know, then the actual advocacy, the actual dispute could take a different turn. So I do think what I'm encouraged by is that a lot of the members of the CAT are lawyers, and that means they're legally trained. They're members often of the Law Society of Ontario, and that means that they've taken the time to study and gain knowledge in areas of evidence, and all the other elements that go into really this area of administrative law. One of the other things that's going to come to fruition for all the lawyers that practice in this area is much more in-depth knowledge on administrative law. Administrative law is a very specific area that talks about fairness, procedural fairness, natural justice, right, and the rule of law. And that's where our expertise is going to blend, because we are still going to have the courts that relate to condos, and we're going to have the CAT. So I see this division of the data. Now I'm starting to put things into baskets, and I see the division and the creation of these areas of scope of authority being very valuable. I myself am a condo owner, condo director. I see it from all the sides of the table, and I see real merit in this. And I'm very, very optimistic that this is going to be a really great stepping stone forward. But at the same time, I think to add to efficiency, I think advocacy should be done in a way that it doesn't put people in a position where they don't feel they have the right to have an advocate. And I think that's an important piece that we need to stress as we move through this. So why don't we take some questions? I noticed that we have a few here. And Pat, thanks very much for your first question about the quorum requirements for the AGMs. Quorum requirements have not been reduced, except where the Act provides for circumstances where the meeting has been called before. So what's happened is you've called the meeting, you've expected 25% to show up, they haven't, and we're recalling it. Then the threshold goes down. But in these times, the quorum requirements haven't changed. But when you bring up quorum requirements, it also triggered something else in my mind about the bylaw. It's important to remember that when we're passing that electronic meeting and voting bylaw, the requirement for approval is not 50% plus 1 unit. It is a majority of the people who are present at the meeting vote in favor of the bylaw. It's a lower threshold because it means that really it's going to be at a minimum a majority of 25% at a meeting that's held for the purpose of approving that bylaw. Going forward, should the CAT be mentioned in the bylaws under mediation and arbitration? Victor, what do you think on this one?
Sure. So most mediation and arbitration bylaws that I've seen in various condos, it really doesn't contemplate the CAT because the CAT only came into force in about November of 2017. So the mediation arbitration bylaws that you likely have at that condo don't actually encompass a CAT. Now, the question's always been, do we redraft and include the CAT? I would say no, because right now the CAT has its own rules of practice. It has its own statutory jurisdiction, which will override your mediation arbitration bylaws anyway. The CAT's jurisdiction is from the Condominium Act and the regulations there too. Those override the condo's declaration bylaws and rules. So you might try and talk to your condo lawyer about refining perhaps some small points about the CAT, but it really won't change the statutory regime that is already in place. And mediation arbitration already is a part of the CAT in stage 1, which is the negotiation part between the parties directly. And there's a mediation stage 2 between the unit owner of the condo and a mediator from the CAT. And stage 3 is the arbitration, basically. So that kind of mediation arbitration framework is already built into the CAT's existing statutory regime. So I don't think it has to be included in those bylaws. Those bylaws should still be in place to talk about other issues and other disputes that aren't in the CAT. For example, like Julia mentioned, Section 98 agreements or shared facilities agreements or electric vehicle charging station agreements. Those will still be under private mediation arbitration that could be contemplated by that bylaw. Patricia, do you want to add to that?
No, I think that's great. That is very important. There's another question here that if a condo corporation does not hold its AGM by the prescribed date, October 22nd, what ramifications or penalties exist? Julia, do you want to take that one?
Sure, I think we talked about this in our previous CondoWise session, and basically we came to the conclusion that there's really nothing that's going to happen, except that perhaps the unit owners will take the condo to court and you'll be ordered to hold your AGM, but that doesn't take away from the requirements under the Act, and condos should be doing all that they can do to practice good corporate governance and to hold their AGMs.
Yeah, I would agree. And I think it's more about getting all of this in place and making sure that the AGM is held. I don't think you can be penalized for trying and even failing, just as long as you show good intention that you have had the attempt made so that unit owners can participate in their condos. Are there any other questions? If not, I wanted to thank you on behalf of Julia, Victor, and myself for being with us. We really appreciate it. We do advise that this is not legal advice. You should speak to your corporation solicitor to get their take on it. But we're always happy to have you with us and to have some questions asked. These recordings are available. I noticed, there's quite a group of you online, and if you could share them with your teams, we would very much appreciate it. So until our next CondoWise event, take care, wear your mask, wash your hands, and be good to each other. Take care. Bye-bye, everybody.